Good afternoon, everyone. Welcome to another session with Accent Realty, where we talk about property issues, relatable ones in Nigeria. So today it's a very simple topic and a very relatable one, in the sense that this is something that at some point we must have been involved in. And the topic is simply disputes in property transactions, alternative dispute resolution vis-a-vis litigation. Now, at some point in each and every one of our lives, we all must have been involved in some form of dispute. Now, when you hear the word dispute, don't let it stress you. Just think of disagreement. Just any situation where your thoughts with another person does not align in any situation. Does not aggressively align. Now, emphasis on the word aggressively, because obviously sometimes when you're having like conversations and all that with people on different issues or whatever it may be, you may disagree at some point. You may not agree, but at some point, it's something subtle, something simple, because at the end of the day, it's something that you can easily reconcile. However, when you hear the word dispute, it goes beyond just a mere agreement, because at that point it becomes a dispute when, one, both parties have different views on a particular situation, and two, none of the parties are willing to accept the view of the other person. That's why it elapses, that's why it continues, that's why it lasts. So, bringing that description into this, the essence of this topic is to outline several disputes that may arise within property transactions, and then obviously when disputes arise, what is the next thing to do? Solve it, resolve it, settle it. Because in as much as you have different views, the reason why you are holding on to your own view is to let the other person either accept your point of view, or in some cases, though few at times, you tend to maybe you want to have a compromise between yourselves. So when the dispute comes up, the next thing that ordinarily should follow is how to resolve it. So in this situation, we are going to look at two major bodies. One of it being alternative dispute resolution, and the other being litigation. Now, mind you, alternative dispute resolution and dispute resolution mechanisms are two different things. Why do I say so? The first one, I said alternative dispute resolution. Alternative is the key word there. An alternative, that is, apart from this, what other forms exist? So, when you hear alternative dispute resolution, what you should be looking at are other forms of resolving disputes aside something. And what is that something? What is that thing? Litigation. So whenever you hear ADR, alternative dispute resolution, your mind should always go to other forms of dispute resolutions aside litigation. Now, when you hear dispute resolution mechanism simpliciter, you are referring to everything including litigation. So I deemed it fit to make that clarification, because a lot of people kind of mistake both to mean the same. So like I said, alternative dispute resolution simply means other forms of settling disputes apart from litigation, while dispute resolution mechanisms are all forms of dispute resolution including litigation. So in this session, we are going to look at ADR, other forms of ADR, vis-a-vis litigation in settling disputes in property transactions. Now, before going deep, I think it's needed or necessary to outline at least various forms of disputes that even exist in property transactions. Now, one major dispute that exists is in terms of purchase price. Now, obviously, at the beginning part, this may not be an issue, because reasons why one may wish to buy a property could be based on the price depending on how it is made. But it becomes an issue, it becomes a dispute when both parties have gone deep into the transaction and maybe it's time to make payments, only for the seller to uphold a price or an amount different from what the buyer assumed was agreed to. For instance, now maybe the purchase price or the price as it was, maybe 24 million per acre. Then subsequent to the transaction, the buyer hinted that the price will be negotiated, and maybe due to the intricacies of property transactions, at some point the price was not necessarily, or rather was not renegotiated. So while the seller held on to that price he mentioned, the buyer obviously would not necessarily hold on to, but would believe that there would be a reduction in the price at some point. So when it's time for payment and payment is made, obviously the seller would be like, this is not what we agreed on. Then the buyer would be like, no, that we agreed that we're going to renegotiate, and that becomes an issue. So purchase price, like I said, does not necessarily become an issue at the first instance, because obviously when you see a brief of a property with a price that you are not comfortable with, nothing stops you from walking out. I mean, at that point you walk out. But obviously when commitments have been made, parties have made known their obligations to the other party, only for one person to want to rescind or step out of the contract, obviously that can lead to a big issue. Now, another issue that may arise is in terms of the title to the document. Now, this may not necessarily arise between the buyer and the seller. However, issues relating to title would come up where two parties are claiming to be the owners of a property. We've seen situations where, now this can be for various reasons, apart from fraud, which everyone is probably thinking about. Another instance where there can be a clash of disputes when it comes to title is, I'm sure some of the lawyers can relate to this, where different deed of assignments are registered at different ministries of land on the same property. So in that instance, obviously this one would claim that he's the owner because he has a registered document on that land, and so on and so forth. So issues like that, obviously the courts would have to look into different scenarios in terms of how you got to acquire the land, how they will look into apart from the legal interest, that's that document, they will also look at the equitable interests leading to your acquiring that property, and this will warrant looking at the situations, how you got view of the land and things like that. So that's for title disputes. Now, the next one is in terms of disclosure. Now, in law, there's something called full disclosure, partial disclosure, and non-disclosure. Please take note that the only thing permitted is full disclosure. So far as you are dealing with someone, you are expected and mandated and required, except the law states otherwise, to present all facts relevant to that transaction, keyword, relevant to that transaction, to the other party to enable him make what is known as an informed decision. Now, partial disclosure, as the name connotes, half and half. You make known half, you hold on to the other part of the information. And then non-disclosure, as its name connotes, simpliciter, you made no disclosure to the other party. Now, like I said, the only thing permitted is full disclosure. Even partial disclosure is not regarded, because if you are doing things in utmost good faith, why would there be the need to hide some facts away from the other person? So that's why even partial disclosure, because some people will claim, but I told you this, I told you that. That does not matter. The fact is that did you tell the other party the necessary things? Now, let me bring it home. For example, one, let me use sale of land, or even rent. You want to rent land, because these are the two very basic transactions that take place with regards to property. So let's say you want to buy a property and your intention was to buy a new house, a new building, in addition to the land, obviously. And you asked for briefs and someone presented a brief to you, but showing the picture of the property was the picture of the property, but the picture of the property when it was initially built. In other words, that picture does not represent the current state of that property. So in situations like that, where I don't really see the chances of one buying a property without going to inspect to ensure that what you are buying is what was presented to you. Because I remember some time ago I made a presentation on the need for physical inspection. But let's assume that physical inspection was not made, only for you to buy a property in whatever location, but only to discover that the property you bought, that the building you bought, was an old one with major structural defects in terms of cracks on the wall and all that. Now, in that case, that's a good example of non-disclosure. Yes, in as much as the picture that was sent was the picture of the same house. However, obviously that was when the building was earlier built. So that cannot and should not be the representation of the current state of the house. Now, it would have been a different case where I would want to buy a property with a new building, but then you have a property, but it's an old building that is there, and you make that known to me that the property is an old one, but it can still stand the test of time, and you are able to convince me to look out the property, check out the property, which I eventually do, and I'm satisfied with what I'm seeing. Obviously, the only thing that may happen would be that since it's an old building, I may request that the price be brought down a bit, given that my initial plan was to get a new building and not an old one. So in that instance, that's full disclosure. You've made it clear to me that this is the situation on ground, and I have made an informed decision in the sense that you've given me the necessary information I need to make my decision regarding that property. So now in terms of disclosure, these are the things they look out for. Now, another aspect of disputes that come up in property transaction is in terms of what is called zoning. Now, I'm sure that, or rather, I want to believe that, or let me not speculate. Let me just say it as it is. So, in terms of property registration at the lands registry, now, not all properties are slated out for residential purposes. Some properties could be for agricultural purposes, it could be for commercial purposes, it could be for industrial purposes. Industrial and commercial can be regarded as the same. So in a situation where you desire to buy a residential property, or no, you desire to buy a commercial property, but end up buying one meant for, or you desire to buy one for residential, but end up buying one that's an agricultural land. Obviously, you may not that can lead to a very big dispute, because that cannot suffice as a property that you can comfortably reside in, because what it is slated out for is for agricultural purposes of whatever kind. So things like that, or maybe you buy a property meant for residential activities or for residence, only to apply it for commercial purposes. That would lead to a dispute, because from the onset, if you look at the C of O, the certificate of occupancy, it's usually written in it what type of property it's for. Is it an agricultural property? Is it an industrial property? Is it a commercial one? So, in addition to what I'm saying now, this is another way of letting the audience know that when you desire to buy any property, always take note of the purpose in which you would need that property for, and ensure that the one you are buying has been registered as such. Now, I'm not saying that such properties cannot change, because at some point, maybe the government seeing the development that's occurring at some point, like obviously influx of people and the explosion in population. Obviously, you cannot, lands that would have been used for people to live in, you cannot, slate it out for agricultural purposes when human beings are looking for where to live. So in instances like that, obviously the government you may apply for it to be changed to for residential purposes, and the government will definitely grant it given the change in circumstances. So that can be a way you can circumvent that situation. But take note, if you need property for commercial purposes, ensure that the one you're buying is slated for such, so avoid such disputes from arising in the future. So these are some of, now before I move forward, I want to mention one of the most basic land disputes that always arise, and that's in terms of lease transactions, rent, landlord and tenant. I bet you that if you go to any courts right now, there's going to be at least one case involving landlord or a tenant. Or even if the case isn't ongoing, at some point in the dealings of the judge, of the courts, he handled a property transaction involving landlord and tenant. So this particular dispute can be for a wide range of issues with rent, issues with use of the property, issues with maintenance of the property, issues with non-payment of rent, issues with increment of rent. Literally anything can be an issue when a landlord and a tenant is involved. So these are some of the issues that can arise. Now, in terms of how ADR can be used in property, in settling disputes in property transactions, I'm not going to bore you so much, but I'll just tell you what you need to know. This is it. Land disputes in courts usually last for so long that even parties at some point get tired of. I've seen land cases as old as I am. Now, I'm not going to reveal my age. Take a guess and imagine it. Imagine how, when I was small, that was when the case started. Now, imagine me now, and the case is still ongoing. Land property issues in court take so long for reasons best known to anyone. It could just be that the court is overburdened, which is a basic issue that everyone knows about. The court is overburdened, so obviously adjournments can take months because the courts cannot, adjourn cases to days that are not convenient for it. So it is always best to settle issues amicably. Obviously tempers fly. It's a normal thing, we are human beings. But it is always good, it is always best to compromise. That's usually the issue. No one wants to compromise. No one wants to be the bigger person. No one wants to back out, in order not to seem weak and all that. So, number one of the very easiest modes of settling land-related issues is in terms of negotiations. Negotiation is the best. I won't say it's the best. Let me not say that, because I'm sure there are people there who don't think so. So I want to talk generically. Now, negotiation just simply involves two parties. The parties involved meeting, scheduling a time to meet and to discuss with themselves on why this happened. Because disputes always have something led to it. So it is always best to take note of why that dispute arose and how it can be settled. I'm a lawyer. I'm sure you'll be wondering why I'm not propagating for going to court at first instance. First instance is stressful. And in addition to that, the law already provides for out-of-court settlements before a case comes up in court. Like in Lagos, we have the pre-action protocol form, where you have to let the courts know that, okay, you've tried to settle things through ADR means and it failed. So that's why you're approaching the court. So even the rules guiding litigation basically recognizes the essence of ADR. So it is best you adopt any ADR means to your disposal. We have negotiation, you have mediation, you have arbitration. take a peek. It is faster. And another thing is, in this property transaction, the real estate sector is one sector that almost everyone is involved in at some point. Even because it's a sector with information, that information is truly power. I mean, how does one become an agent? Basically by, okay, you want to buy property, I know someone that can, I will link you to the person. That's simple information that you've given has included you into the chain of transaction. That's how sensitive and, that's how it is basically. So it's not something that you would have to take lightly. And at some point, obviously, if a transaction should go well, ordinarily you would want to deal with such a person. And having to, because the thing is that litigation is a win or lose situation. It's a victor and vanquish situation. So there's no win-win, except where parties decide to go out of court and settle. But so far as you are leaving the decision-making to the judge, it is always going to be a win-lose situation. Or in instances where the court will declare something known as a non-suit. But I'm not going to bore you with all that legal stuff. So that is it. Another thing is, doing ADR will cost you less money. It will. Though if it drags for long, because in ADR you tend to pay the arbitrator, the legal representation, whatever. But you get this difference here is that you can amicably decide on what to pay and what it would cost. So it's always best to involve yourself in ADR. Another thing with ADR is it gives you that, it encourages privacy in settlements of issues. The court is a public place. Literally anybody can walk into the court and listen to any case. The court is not, no one is precluded from going into court. Go in, sit down and listen. So the court is a public place. And ordinarily, or if we had control over such things, I mean, you wouldn't want your issues to be dealt with in a public place, but that's what it is. So ADR gives you that avenue where you can amicably resolve your issues strictly with those involved in those issues and settle it in such a calm manner that wouldn't warrant the involvement of some person at some point. Now, another reason why ADR is really good is that ADR can allow for you to bring in experts in settling disputes. We have, I want to believe that they are very good property transaction experts, the real estate sector. We have property consultants everywhere. So depending on how complex your property disputes may be, you can always involve an expert to come and take the decision on that matter. And the fun thing about ADR is it's amicable, and though the agreements, the decision reached may not necessarily be binding, like in terms of negotiation and mediation, but for mechanisms like arbitration, the decision is usually binding. But the point remains that it's ADR just, it gives you room. It's a flexible atmosphere. You are not confined with the rules of court. You must do this way. You must do that this way. You must. If you don't, go back. If you don't, this. No. ADR is very flexible. It allows you to settle disputes the way you can settle them with no issue. And property transaction is a very big one with millions of naira involved. By the time you take a case to court and it lasts for 25 years, even if you should ask the court for any amount of money that you think would be sufficient as compensation, mind you that as time goes by, the value of money reduces and the value of property increases. So while you are stuck in that transaction, in that court case, that land you are disputing on is increasing in value, and the money that was requested is reducing in value. So you wouldn't want to disturb yourself with things like that. So now, however, irrespective of all this, there may be instances where going to court would be necessary. Now, the number one instance is where ADR fails. One of the usual kickbacks of ADR is the fact that it is not always, like, the decisions are not necessarily binding. I stand corrected, but I think arbitration is mostly the one with a profound binding effect on its parties. But the rest, negotiation, mediation, the decisions are not necessarily binding. So even if you have agreed on a particular issue, the one party can always come and decide not to follow it. However, the good side of it is, whatever you have agreed on, that's why it is always necessary to pen things down. You have a verbal conversation with someone and you reach an agreement, it is always best to pen it down. So in a situation where you have a penned down agreement with both parties attesting to it, all you can simply do is to take it to court and enforce it against the person as a contract. Or yes, you can bring it under breach of contract because you've reached an agreement and the other party is trying to rescind it. So where ADR fails, feel free to go to court. And even in such a situation, the court will be eager to take up such case because you have done the needful. What's that needful? You've approached the ADR field and it didn't work out. So you are coming back to the court as a last resort. That's the point. The court in any property or commercial disputes should always be as a last resort. That's why ADR is here, to at least serve as the first point of call for amicable settlements, after which, if it fails, feel free to approach the court. Now, the next one is where fraud is involved. Fraud is an offense, in other words, under criminal law. Now, I don't know much on the current situation on the ability of arbitral panels to sit on offenses, because usually once it's an offense, the approach should be the High Court or the Magistrate Court, as the case may be. So whenever an offense is alleged, it's always best to approach the court. So these are usually the two instances. When ADR fails, you can't force the other person. You can't resort to self-help. So the next point would be the court. And obviously, when fraud or any other offense is alleged, the best thing to do would be to approach the court. So that's it for the day. Thank you so much for your audience, for your time. See you next time. I'm your host, Benson Okezie Esquire. Thank you very much.